And welcome to this session on recovery of possession from squatters, which I'll be presenting for Legal Futures. I'm Mark Shelton. I'm a non-practicing solicitor and commercial property management law trainer, formerly in practice with the Linklaters, DLA Piper and Evershed Sutherland. Now, when a property is occupied by trespassers, you can't really be too prepared. It's unusual for police to exercise their powers to remove them. So it will be a case of using the court process as quickly and effectively as possible. And this webinar sets out an action plan which breaks down the court process into three distinct procedural phases, and also deals with practical issues such as removal of vehicles and horses. It also considers measures for preventing repeat occupation, or at least meeting it with rapid and effective enforcement. As regards police powers, there's new legislation. It's much wider than ever before. It does raise the question whether police will continue to be an ineffective option, whether landowners still have to recover possession by their own efforts, with all the cost and delay involved in that. So we'll be considering the available options. So the legal analysis and procedure for dealing with occupation by squatters are extremely simple. There are some technicalities to be aware of, but effective action is usually more of a logical and administrative challenge than a legal one. What are we talking about? What are trespassers? Persons in occupation of land without the consent of the person who's entitled to possession are trespassers or squatters. Often they'll be travellers in occupation of an open site, with or without caravans and other vehicles, but of course squatting can take many other forms as well. So, who is entitled to possession? Generally speaking, there must be an entitlement to possession to support a claim, which is, I suppose, not a very surprising proposition. The point to bear in mind is that it's a relative entitlement to possession. So all the claimant has to establish is that they have a better claim to possession than that of the squatters. They don't have to establish a grant of exclusive possession, a lease, for example. So there have been cases where a contractual a licensee, has been able to claim for possession against squatters as long as they've occupied pursuant to the license so as to have effective control of the property. Manchester Airport PLC and Dutton from 2000 is an example, where the occupier was granted the right to occupy land for the purpose of felling trees. But the possession order has to be a necessary remedy to give effect to the rights of occupation granted to the licensee. But obviously,